application under Order 22 Rule 3, Lordship. The sole plaintiff has died.
Which matter?
Lordship, this is CS 80 of 2009, Lordship.
Today not in the today's list.
No, it's not in the list, Lordship. It is out of the list. I'm just praying for leave to file this application, Lordship, along with the Section 5. Grateful, Lordship.
I appear for the plaintiff in this matter, my lord. On the last occasion, your lordship had heard the matter in full. The matter was completed, but some queries fell from your lordship regarding certain things which are to be proved by the witness. The witness was discharged in any event. My lord, what had happened, your lordship, we had already gathered some documents pertaining to your lordship's query. But those are all in one
Price.
Yes, your lordship.
Payment of price.
Yes, your lordship. But those were in vernacular language. So, my lord, what has happened, your lordship?
In Hindi.
We require time to get it translated, my lord.
January?
Very well, your lordship. And we'll file an application in any event because the witness has to be summoned again,
That is
your
separate
lordship.
issue. But
That is a separate issue, my lord.
once it is translated, then you file an application.
Yes, your lordship. Exactly.
Adjourn to 30th January.
I'm grateful, my lord.
If you are able to do this beforehand,
then we'll mention the matter and we'll get it listed before my lord. I'm grateful, man.
আগের দিনে কি অর্ডার ছিল? লাস্ট অর্ডারটা দেখি। In terms of order dated 13 September 2023, the learned receiver, Mr. Banerjee, was directed to submit reports, audited account from 1st July 2021 till 31st August 2023. First up, today, neither the report is submitted nor Mr. Banerjee is present in the court. Let the matter appear in the list on আজকে কত? আজকে 18 December. A copy of this order shall be communicated to Mr. Banerjee as well as Mr. Dey. Both shall be present before the court on that date. Aye. My lord, it is my application which has come at my instance, my lord. This is item number 2. What about 9, 9, 10? My lord, these are all applications by the most probably Bajrang factory, my lord. If I'm not wrong, no, these are other applications, my lord. But in the last occasion, your lordship had indicated that your lordship is inclined to solve this dispute of mine, and the other applications can follow. Hints was given. Directions were given for me. Not direction, hints was given. Yes. I stand corrected. Lord, expression of desire was made. Oh, Lord, it was across the board. Everybody agreed to that also. Now, my lord, I obtained a leave. I was granted a leave to file a supplementary affidavit to put on record an order which I'm seeking recall, modification, whatever. That because of my mistake, my lord, by chance I missed it. So that affidavit is ready. And there was also a direction, my lord, that the applications be served on all the respective parties. We have completed that, my lord. These are the letters evidencing that I have served. File affidavit of service. Affidavit of service will be prepared and filed during the course of the day, my lord. Leave is on prayer. On prayer, leave is granted to file supplementary affidavit to the petitioner in GA 11 of 23. That leave was given in the last order, my lord. I have prepared that affidavit. That may be taken on record. Okay. May be taken on record. Line taken off. Supplementary affidavit is filed today by the petitioner in GA 11 of 23. Mine. Affidavit of service is not there. Affidavit of service, my lord, the letters are here, all endorsed. Affidavit of service is to be filed. Mine. By the petitioner. And earlier, my lord, we supplied all the copies. Affidavit is filed. Which is the other side? My lord, my learned friend is most probably for the receivers. I think. Yes, sir. Is for the receivers. Calcutta University is being represented by Mr. Chatterjee, Nilut Paul Chatterjee. His junior is here. And Bajrang factory, of course, the plaintiff. And so you file affidavit of service? Yes, I for these two letters, my lord, I'll file. Yes. But all are served. All are served, my lord. All are served. So what is your prayer? My prayer today, my lord, if your lordship kindly hears me out, partly at least, on the merit of my application. Because, my lord, my application is a very innocuous application. I shall place all the facts. I am trying to take a modification of that order, but perhaps, my lord, the order which I am seeking modification by this application, my lord, is a very innocuous, neutral order. What is that prayer? My lord, prayer is, my lord, that my final prayer is, my lord, the tenancies which were created by the receiver are illegal. And they had no authority by their order of appointment, and clarified also in 1995, I've annexed that order of this court. Now, my lord, the question is, when the receivers were asked to file their affidavits, they filed 2 reports. And I'm going to the crux, my lord. In that report, which made the court, my lord, this honorable court, to pass the order which I'm seeking, they relied heavily on the version of their manager. And the manager, they said, the receiver said that we have whatever tenancies we have created, done and all, we heard the manager and did it. The proposal in your report that the tenancy may be divided. Yes, my lord, that came from... Lord, that we had given.
Now, my lord, as on today, as it stands, my learned friend is claiming a right through a deceased tenant. There is a contention between him, my learned friend's client, and another party, that they have the right over the particular shop room. Now, this is a question that has to be decided separately in a separate trial.
No, not at all. I'm not on that.
Who will inherit? How, who, and who is going to...
That I express, that opinion I have expressed.
Yes, my lord. So, I can't decide that. Whoever was there...
No, it's not. You cannot decide that. You need not decide that.
Yes.
Try whether it can be done. Because hints was given in your report.
Yes, my lord.
This may be way to sort out the issue. May I make a prayer, my lord? May I make a prayer, my lord? I am not coming down on the receivers that you decide my case, as your lordship pointed out. But what I am suggesting is twofold. One is that what you have done with Mitali Paroi, and Mitali Paroi now has changed hands and taken money and all that, that itself from the root, you had no jurisdiction authority vested in law to do. And today, if I have to assail the actions of the receiver, I have to come to this court. No court in India has authority to touch them. This court has, because this court appointed them. If they have done wrong, I have to come to your lordship. Lord, it is not a question of independent proceeding or suit. They are insulated by the power of this court. They are this court. Now, my lord, the question is, but after hearing long protracted hearing, your lordship came up with their hints, your lordship's indication. I'm not saying order or imposition, but indication that do what is correct. Now, my lord, today I am happy, like in Mahabharata. He said, you give me 5 villages, I am happy. So I am happy. My lord, if your lordship, 2 things. If your lordship appoints a special officer, receiver hands over possession, special officer stays there, I demarcate temporary demarcation of the shop, put a collapsible door. Lady, my lord, lady, that is why I'm saying so. Because there is a lot of problem. I don't want to go into that. What Mitali Parai has done, sold, she will face the consequence.
Have you got some space?
Yes, 1/3 space I have, your lordship indicated, 1/3 to me, 1/3 to my brother-in-law.
Have you got any space?
Yes. I have possession in one shop. They are not allowing me to enter into that shop. I am forced to keep it locked. Because whenever I'm going, that Mitali Paroi has created a third-party interest, that person is abusing me, is physically attempting with local goons. So I need possession, I need locking.
Got your point.
My lord.
Twofold submission. A, whatever my learned friend has submitted, that is completely beyond the prayers in the petition. 1. 2, on facts and on the ground, he is not in possession. Whatever submissions being made.
In your report, they are not in possession?
No, they are, because I cannot ascertain. Somebody is there in possession. They are claiming 1/3 right over that particular shop premise.
No, my lord, I shall indicate from the receiver's report itself
Where
what is
is
the
this
position.
report?
Well, we had
Ma-
filed it in the earlier application.
I have annexed it to my report.
And my
My
lord, if your lordship is pleased to appoint a special officer, I have no difficulty. Only one thing, lordship will discharge me, because I do not want to take this on myself, because my learned friend is not a party to the suit. None of the parties to the suit
I have been
come up.
intervened. That argument is
you
now
have not
old.
allowed.
I have intervened. That argument is now beyond the realm of
No.
again raising the trust.
Your intervention.
Where is that report?
My lord, I'll indicate, my lord. If your lordship kindly, my lord, takes page, my lord, kindly takes, my lord, page 100 and but the report is, my lord, that page, the receiver's report. Receiver report টা কোন page আছে বলো তো এক second? Lord, 1 minute. I've indicated. Lord, I've annexed, my lord, the report also. এই রিপোর্টটা তো অ্যানেক্স করা আছে। এই my lord, kindly take, my lord, page 135. 135, my lord. 135, or rather, my lord, 138 of my application. My lord, the last annexure. My lord, 138, page 138. My lord, this is the charge sheet. This is the charge sheet, my lord.
Where
Which,
is
my
the
lord,
report?
report আমরা annex করেছি তো এর মধ্যে। We have annexed the report. Where is that report?
Page
96 of the application.
My lord, 96, my lord, 96. 96, my lord, 96. 97 is the place where it starts. That is the report. '96.
No, not this report. And another report was there.
Another report was there. That also I have annexed.
Where it was hinted.
Where it was hinted. Yes, my lord. That also I have.
Of that, I passed the order.
Yes. কিন্তু পেজ নাম্বারটা একটু তোমরা অ্যাসিস্ট্যান্স না দিলে আমি তো ভুলে যাই না, এটা কি মুশকিল রে ভাই। Second report is also there, my lord. My lord, kindly come to page 115. 115. I'm sorry, my lord, I took a while. 115. That is where the
affidavit.
yes, that is the second report.
That is affidavit.
That they filed it in the form of an affidavit, my lord. And my lord, that and sorry, my lord, kindly take 131. 131. I'm sorry, my lord, I apologize. 131.
That is the exception to the report.
Come, get ready. This cannot be done this way. Adjourn to 17 January.
Great. Lord, I appear on. We are one of the applicants, Lord, item number 9.
Item number 8
When
is
it-
my application.
when it is called.
Item number 9. Mithali
What is
Paroi.
item number 9?
Lord, I'm the applicant in item number 9. Lord. It's an application by Mithali Paroi. But she's not getting the rent bills from the receiver, Lord.
All
It's
these
not
matters
being
shall be
paid.
taken up together.
But item number 8
17.
is my application. I have taken out a supplementary affidavit to indicate that the landed special officers are collecting unauthorizedly money from some of the occupiers and not denying receipt of the occupational charges of some of the occupiers. In that aspect, that application has been filed. I am filing a supplementary affidavit with that. To additional.
Very supplementary affidavit.
But it's getting affirmed now. I'll supply.
Come on the next date.
Yes, sir. Kindly,
The corporation, I have also prepared a report for your as per the.
I asked you to submit a report on pending taxes, outstanding taxes. Where is that affidavit?
Lord, only this, Lord,
That
let
is
the
in-
special officers issue the rent bills, Lord, to my client, Lord. আরে আমি তো রেগুলারই আছি ইরেগুলার কোথায় না আমায় নিয়ে গন্ডগোল না।
GA11 এ লেখো
গন্ডগোলটা ওই
adjourn to
জায়গায়।
17 January.
আমি নগর
এবার হচ্ছে
তমুল।
which matter you are filing that? এবার GA10 of 22 তে লেখো a report is submitted
আর enormous গরম হয়ে যায় কোর্টের।
GA10 এ এটা by the learned counsel for the Kolkata Municipal Corporation. দেখি রিপোর্টটা দেখি।
সাপ্লিমেন্টারি টাইম হচ্ছে তো এগুলো পার্টি করে দেবো আমি
এটা কপি দিও।
এটা দিয়ে কত
Let the same be kept in record. Copies of the report be handed over to the learned receiver.
তুই আরেকদিন বল পাঁচবার বলেছি
বললাম তখন বেশি বলে দিচ্ছে।
The learned receiver shall make a calculation as to outstanding amount of corporation tax and proportional share thereof by the respective tenants and or occupiers,
তুমি
including the name of present occupiers. Report shall be submitted on the returnable date, namely on 17 January. What about GA5?
GA5 is that application, but Archive has granted us a liberty to file a supplementary affidavit, which is being affirmed today, right now. So Archive kindly gives
Supplementary
me.
affidavit is not filed today.
I know I could. It's being affirmed today.
GA5. Affirm, that means as yet to be filed.
Yes.
Is yet to be filed as submitted by the learned counsel for the petitioner. It is GA5 of.
Association.
Let the matter appear in the list on the returnable date. GA6,
GA6 is my application. Mithali Paroi, my lord.
exchange of affidavits are complete.
Affidavits have been completed, my lord. Affidavits have been completed.
On that date, I will take it up.
But only one.
Only this, my lord, the rent bills could be issued to me, my lord. That's the issue.
That
No,
cannot be
my lord,
taken
that is not the
that-
issue, my lord. My
That
learned
cannot
friend,
be
my lord,
passed
is
in
not aware,
isolated way.
perhaps.
All the issues have to be connected together.
I have a
And if
Because
get
they were
ready
trying
next
to install a collapsible gate in front of my shop. That was one of the reasons, my lord, as to why I filed
All right,
it,
come on the next
petition.
day.
But only one request, Lord, let this report be circulated amongst everyone, because it
Otherwise-
concerns all of us.
So only receiver will take it.
But it concerns all of us, right?
Receiver will do whatever the be the needful.
Wait,
When as and
Receivers
when
are not
necessary.
doing whatever is
but
needed.
our
Kindly
application is
not
for
direct the
discharge.
receivers to do
Our
that.
application is for discharge of the receivers, my lord. So,
I'm willing to be
so my lord,
discharged,
if
right?
I do not get a
Let
copy,
these things be done first, because you have, so far as you are continuing to do the work,
Yes, my lord.
this exercise is to be done.
Absolutely. I'll do it, my lord, and what will kindly consider my
But
prayer for discharge.
Let Mr. Ghosh be there, otherwise,
Not Mr. Ghosh, please.
the learned counsel will not be there.
I will walk.
Adjourn to
Grateful, Miller.
17th January.
Well, all the Miller matters on 17. I'm grateful, Miller.
lordship has extended my time to file supplementary affidavit, my lord, for 1 day. I'll finally put it.
ওখানে যেটা ওই কোনটা বললাম যে
Yeah,
5
5 years.
time is extended to file ওখানে লিখে দাও supplementary affidavit.
Grateful. my lord.
Item number 3.
I'm appearing on behalf of the petitioner, your lordship.
Hmm.
This is a substitution. Your lordship, I am appearing on behalf of the petitioner, your lordship. This is a substitution application in a revocation of the probate proceeding. Your lordship, this
Revocation.
Mr. C.K. Jain and company is appearing, your lordship. This is a substitution. This is simply a substitution application.
Appear at least.
Yes, your lordship. We have served them. The affidavit of service is in your lordship's records. Your lord.
Fixing another date, 2 or 3 days after, I'll pass order. None appears for the defendant today. To the appears for the
Your
executor
lordship
today.
can pass the order because it is within the limitation also. Within 90 days period. Your lordship kindly
Filed
sees.
it. So there is no issue. None appear. Master summons to the none appears for the respondent executor. Executor.
Yes, your lordship.
Mr. Dotto, the learned counsel for the present petitioner, submitted that affidavit of service has already been filed by him in this court.
And they did not appear on the previous occasion also.
GA10 is filed with a prayer for substitution in view of who expired?
Your lordship, Purushottam Lal Sultania. The
But
party
about the
number.
time,
Your lordship, the death certificate is at page 13, your lordship. And Purushottam.
who will be substituted?
The
Purushottam Lal
petitioner, your lordship. The petitioner.
Sultania.
Yes, your lordship. The petitioner.
Purushottam Lal Sultania.
Yes, your lordship. The
In view of death of the present petitioner,
yes, your lordship.
which took place on 29/8/23. Let prayer A2 What have you done this?
Your lordship, the prayers are there is a
See, what have you done?
your lordship after A and B.
Yes.
Your lordship kindly grants me a leave to rectify that mistake, your lordship.
Prayers A, B in page 4, as well as ABC in page 5 are allowed. Department is directed to do the needful. Let the matter appear in the list on.
Your lordship kindly lets it go out of the list with liberty to make that.
No.
Lordship.
That's a very bad practice. That will never come in the list. 30th January.
Grateful, your lordship.
GA 10 of 23 stands disposed of. Check your application. You should check your application.
I apologize, Your Lordship.
Item number 4 to 7.
These are those strategy international matters, my lord. In 5th October, my lord had passed a direction for executing deed of conveyance that has been already done, my lord. I'm told that I am for the applicant. The joint administrators were to supply the
Is to submit a report.
my lord, one of them I'm told has fallen down, for which he's not coming to court for some time. If some time is given,
Adjourn to 31st January.
DP.
Item number 11.
My lord, I'm appearing for the petitioner. My lord, the clients in this matter, the clients were out of station. We could not contact them, my lord. There has been a bereavement in their family.
What about GA11?
My lord, I'm not briefed in this matter. My lord, I am praying for 3 weeks time to file reply.
Adjourn to 30th January.
Grateful, your lordship.
Item number 12. Geeta Guptu. Undependent suit.
Item number 13, I am appealing for the petitioner, my lord.
12.
12, my lord, 12. My lord, in item 12, I appear for the plaintiff, my lord. My lord had already said this suit ex parte by my lord's judgment on the last occasion. My lord, I was humbly praying for some time to file the judge's brief of documents, and my lord, issues can be framed. Kindly, my lord.
Issues can be framed. Ex parte matter.
My lord, judge's brief of documents, I have to file the. It's undefended suit. They have not filed a written statement. I'm sorry.
There is no scope of framing of issue.
There is no scope. My lord, kindly.
Issues can be framed.
How?
Sir, with
There is
regards
notice.
to the plaint, my lord, the plaint has the prayers in furtherance of the prayers. My lord,
When issues are framed?
When there is a fact.
I understand, but when a fact is disputed. When
Then
a fact is disputed, my lord, only then the
no
issues
question
are-
of framing of issues.
My lord, only time to file our judge's brief of documents and witness.
An accommodation is sought for by the learned counsel for the plaintiff to file judge's brief of document. Post up granted. Let the suit appear in the list on 10th January.
My lord, for
কোনটা
witness.
খালি আছে কবে দেখো না? January under heading witness
Witness
action.
action. Deeply obliged, my lord.
Judge's brief of document shall be filed in the meantime.
Deeply obliged, my lord.
My lord, item number 13, my lord, I am appealing for
Item
the
13.
plaintiff. I am appealing for the plaintiff, my lord. On the last occasion, your lordship was pleased to direct the defendant number 1C to file additional written statement in view of their submission that originally defendant number 1 filed a written statement which they have found out from the records of this honorable court. And now, my lord, you have your lordship directed the plaintiff to cause substituted service of summons. And to that extent, my lord, we have filed an application. It is before judicial scrutiny, before the department, my lord. It will come up before your lordship anytime. In the meantime, my lord, kindly adjourn the suit and we'll keep it after vacation anytime, my lord. In the meantime, the substituted service application will
Adjourn
come
to 22nd January.
Oblige, my lord. Oblige.
Item 14.
Item 14 also, my lord, I am appealing for the
Same.
No, my lord. Now, your lordship on the last occasion, last week, my lord, your lordship was pleased to observe that from the report of the department filed before your lordship, an application was pending and which the department have found out. This is a matter, my lord, where the records were not found in the department. And my on record has also misplaced the briefing on earlier occasion. Now, my lord, I have
certified copy.
I have pointed out to your lordship that substituted service of summons was done, my lord. An application was filed, orders were passed, paper publication were made, and an affidavit to that extent is also with my advocate on record, which is not an affirmed copy, but an office copy of the affidavit, my lord. Now, that affidavit and the other documents which have been filed in the suit from time to time is not found in the records, my lord. Certified copies have been applied time and again before the department could not produce the copies of the record, my lord. Now, in this situation,
2 copies of the affidavits which have been filed. I have not been able to look into it. Leave be given to look into what are.
now
Whether written statements were filed.
They have
no, they have not appeared in the
they
suit.
have entered appearance, some of them, but they have not filed the.
Yes, my lord. They have entered
Is there
appearance.
any report of the registrar?
My lord, your lordship was pleased to call for the report on the last occasion wherein 2 affidavits are available in the department.
Non-filing of written statement, report is there.
No step was taken by the plaintiff's advocate for service upon defendant number 125 so and so. So you file a supplementary affidavit stating that all these things were done.
I shall do that.
My lord.
I shall
My lord.
A leave is granted to file supplementary affidavit to the learned counsel for the plaintiff. Have you got a copy of this report?
No, my lord. We have not got.
Only inspection, because I have make some marks. Check it. Check it, take note.
Which are filed
Liberty is given to inspect the report of the learned registrar and take notes from that.
My lord, a leave be given so that the 2 affidavits we have been found by the department may be given to us. We have applied for the certified copy. That may be given to us. On the last occasion, the report of the learned registrar
That's
says
up
that.
to you and the registrar. What the court shall
we shall-
pass.
we shall- we shall.
What is the next date fixed? I said
April, January.
My lord, any time in January.
let the matter appear in the list on 22nd January.
Obligement. Obligement.
Item 15.
I'm for the respondent, my lord.
Who is the plaintiff?
My lord. Rohit Banerjee and Arindam Pal.
Rohit Banerjee is not appearing. He is supposed to appear today in another matter also.
Keeps it next day, my lord.
He is in court 6, my lord, right now.
Well,
Keeping Passover.
my lord, kindly keeps it. Not today, my lord. Kindly, my lord.
My lord, item number 1 also, Mr. Banerjee was appearing.
Yes, I passed order in that matter.
Oh.
Not today. 15, not today.
16.
16, my lord, I appear on behalf of the respondent, my lord. I have an innocuous prayer, my lord, on the last
My
occasion.
application.
On the last occasion, my lord has granted the learned advocate on record of mine to inspect a document, my lord, he couldn't carry out because of his personal difficulty. Kindly, my lord, gives me some more time so that I can inspect and keeps it
On
any
prayer of the learned counsel. What about this J54?
J54 is the main application.
My application is for cancellation of a purchase deed of the respondent.
Of our, we are the.
So I filed an application. That application is being, everything is complete. Our argument is also complete. While they were making submissions, they said that they will take inspection of my deed and the original title deeds. And Lordship asked us to produce. We produced. Those are kept with my advocate on record. They were supposed to take inspection. So, now they are seeking time for that purpose.
Accommodation is sought for by the learned counsel for the
respondent. My lord.
Respondent. Granted. Inspection is to be done within the returnable date. As granted, let the matter appear in the list on 5th January. 16 January, you said? 16 January.
16 January. Very good.
Item 17. In this matter, my lord, I am opposing the application filed by my learned friend's client. I am the plaintiff in the original.
I have heard it at length.
Yes. On the last
Basic
occasion,
issue is this suit is not maintainable in the present form.
that is what they are saying. My lord, our submission has been the reliefs can be molded and that they have accepted the jurisdiction of this honorable court inasmuch as for 1 long year, my lord, they have been accepting and they have also filed the.
I have heard both of you. Would you like to file any notes of argument?
My note on argument as regards my submissions were already filed. They had also.
Would you like to file any notes of argument?
I have also filed, my lord.
So I'm reserving for order.
No, only one thing is.
My lord, in my note, I had not distinguished the judgment because I did not know what judgments they are going to cite. So your lordship on the last occasion had given me a liberty to file a supplementary note only distinguishing the judgments of my learned friends.
When will you come?
Lord, I have prepared. I have it.
Give a copy.
Yes, my lord. A copy should be provided to us.
I have a copy.
Okay. And my lord, we have already submitted our note.
Argument is complete. Reserved for order.
Obliged, my lord.
A little bit time may be needed because I have 3 or 4 matters for passing
As your
order.
lordship pleases, whatever is convenient to your lordship.
Much obliged.
Item 18. Lordship, in this matter, my lord, I am appearing for the my lord.
Same matter coming again and again.
I am
My lord, I
appearing
am sick of
for
it.
defendant number 10, 10A and 10B, your lordship.
My lord.
My application is GF 149, where we have
Why you have come again?
My lord, your lordship was pleased to dispose of the application, my lord.
Yes.
My application was 693, my lord. That we have come up with your lordship again, my lord, because recalling of your lordship's order, my lord. There is some, my lord, kindly see the order, my lord. Once, my lord, I am placing. I am led by Mr. Dhruva Ghosh, my lord. He is on his way, my lord. He is coming. I am placing before the.
lordship, may I be permitted to place my application?
On behalf of
Let me see this order
the
first.
person.
Yes, what is your problem?
My lord, my lord,
My lord, my application is my lord GA number 149, my lord.
in this application,
Which order? Order dated?
my lord, the person appearing on behalf of respondent number 7A.
I'm not hearing you.
My lord, in connection with GA 149, I am appearing in
Let-
person.
Don't intervene.
Jayanthwati is seriously ill, my lord. That is why I.
All right. Let me hear him. Let me understand the case. Yes.
My lord, lordship kindly come
I
to my.
adjourn this matter, my lord, today.
আমি বলছি তো বলতে দিন।
Why are you interrupting? Why are you interrupting? He may be ill. At the time when I will give you patience hearing, don't you know the basic etiquettes of the court?
My lord, my lord, kindly come to my lord page 28, my lord. Annexure A, my lord. Your lordship's order, my lord. Order dated
You
14.
tell me which part of the order.
My lord, your lordship,
Is
kindly
already-
come to my lord page 30, my lord. Your lordship's operative portions of the order, my lord. Before that, my lord, page 29 at the bottom. Before that, my lord, page 29 at the bottom, my lord.
The learned counsel.
Learned counsel for the defendant number 7A and 7B submitted today that if appropriate flats are offered, client are ready and willing to accept the same and the same in the newly constructed building at 27 Chetla Central Road and 92 Rakhaldas Road. After hearing the concerned parties and learned receiver,
Certain orders were passed.
it is your lordship. Your lordship order, my lord, kindly see, my lord. Number 1, Roman number 1, the intervener developer shall accommodate the defendant number 7A and 7B in suitable accommodation during the construction. Demolition work shall be initiated.
What is your problem? Tell me.
Well, I am saying, my lord, kindly, because my lord, I am, if I am not placing your lordship, the earlier portion, your operative portion will not be any meaning, my lord. That is why I am placing, my lord. Kindly give me a short time, my lord. Demolition work shall only be initiated on shifting and or relocating the defendant number 7A and 7B. Intervener developer shall carry out the scheme framed by the Supreme Court of India dated 26th February 2013 in true letter and spirit under supervision of the learned receiver. Receiver shall submit compliance report after 6 months. Now, my lord, here is the problem, my lord. Intervener developer shall hand over suitable flat to the defendant number 7A and 7B after construction at 27 Chetla Central Road and 92 Rakhaldasadi Road. My lord, this portion is troubling. Otherwise, my lord, there is no problem. Why, my lord, troubling is, my lord, that 27 Chetla Central Road and 92 Rakhaldasadi Road already amalgamated. It has already been constructed. We have offered them. They refuse to take. They refuse to take any accommodation in because they have their reservation something, my lord, but they have refused. Now, my lord, we have handed over the flat the other co-sharers. Now there is no accommodation. Now we are saying, my lord, a construction will be developed at 84 Rakhaldas Addi Road, and we will accommodate according to their share, my lord.
Let them come on the next day. You consult with your client.
My lord, number of occasions they are not agreeing, my lord, because my lord, Supreme Court has already said, my lord, either they will take the accommodation or they will.
I will pass order as you want.
Well, I am not because your lordship was. Well,
you submit a report or submit your statement. Consult your client. Come on the next date.
Well, number of you have submitted the report.
Not you. He will come.
7A, Jayantu Addi, in his application to the opposition of the recalling application, has stated in brief detail that the Honorable Supreme Court, whatever the order has been passed in favor of myself, that is clearly stated there
that the 84 Rakhalda Road is, we want this space, I mean,
Where is your opposition?
broad area, and the narrow place has been offered to us. That is why we are not able to take that 27 and 92. We want 84.
Who is the receiver?
The receiver is not present.
Receiver is,
Mr. Ramesh Sharma is the receiver, madam.
because 7B and 7A, they want
All right.
also
I am passing
a
order.
different space.
Take instruction and say to the receiver in
Such
the
a
time.
space is wanted. Kindly comply the order of the Honorable Court.
On a written statement. On the basis of that, I have made an application under or allow me to hide a written statement.
Which one?
Application 151 of 2020.
Let me dispose of this application first.
In direction to start copy to the others. One five one.
এইটা দেখো GA 149 of 23 of 23 is filed with a prayer to recall and or modify the order passed by this court on 14 July 2023. For reasons stated in the application. It is submitted by him that
My lord is passing an order in 149.
yes, that up
But I would just like to file one affidavit in this.
কি বললেন?
Application.
Full stop. It is submitted that they have offered flat at 84 Rakhaldash Audi Road.
No, my lord. They have offered 27 and 92. But the Honorable Supreme Court has asked us to take the flat in the 84.
No.
We want 84.
That is not indicated.
Where is the order of the Supreme Court?
Your lordship kindly come to my lord. That is
It is not indicated.
উল্টো পাল্টা বলছেন কেন জজ সাহেব কেন কনফিউজ করছেন জজ সাহেবকে জেনে আসুন ভালো করে মানে পেজ 68
You do one thing. You do one thing.
Lord.
Next time, come prepared. Otherwise, don't appear in this court.
My lord,
কি বললাম? I will bar you from appearing in this court. দরকার নেই appropriate modification.
790.
Just like to file it up to the.
কি বললাম? Where is the order of the Supreme Court?
my lord page 68 my lord of this application my lord
It is submitted by the learned counsel for the petitioner that offering flat at 84 Rakhaldash Audi Road would be more in consonance with the order of the Honorable Supreme Court of India. Instead of 27 Chitla Central Road and at 92 Rakhaldash Audi Road. Full stop. The learned counsel appearing for defendant number 6. He's for 6.
he is for 7A my lord 7A my lord
7A and B possibly.
7A is
7B is not representing today, my lord.
7 is not
7A
representative to his favor, my lord.
submitted that his client is not agreeable to that. 7A and B, 7B, both are mentioned here, are not agreeable to that. Full stop. This is a long pending dispute between the parties. The learned receiver shall sit with the parties together for conciliation and submit a report.
My lord, may I make one submission? Well, is already 3 occasions receivers seated. We have seated personally, my lord. There is no way out, my lord.
Let the report come. You will them? Come on the next day, you underline which parts were the Supreme Court specifically stated, because I have lost a track.
My lord.
And next day, if you interrupt without understanding anything, I will not allow you to appear in this court. This is not a place of jokery.
My lord.
My lord, may I request one thing, my lord? Since it is long-term pending, my lord, and your lordship was just now said that it is, your lordship was, could not track the, my lord. If your lordship is possible, my lord, can it be fixed before the vacation, my lord? Otherwise, my lord, it is, my lord, because my learned friend, let me.
Has to sit with the parties, my lord.
Well, it is only concerned with 7A and 7B, my lord. Only with my application is restricted to only 7A and 7B.
For the report of the receiver on 21st December.
Can be on the reopening. Now, may I just indicate?
151. Let me have 151.
Direction may be given to start copy to the all of the parties.
What is your prayer in 151?
The prayer one of the leave may be granted to the petitioner to file briefing statement by condoning delay of 3160 days.
When the summon was served?
I am a substituted defendant.
When you are substituted?
That has to be
3160 days. Condoning delay of 3160 days.
Wants to complete.
Have you served copies?
No, I want to direction maybe.
GA next GA 151 of 23 is filed by you are added defendant.
Defendant number 12A.
Defendant number 12A. Praying for leave to file written statement condoning delay of 3160 days. Copy of the application may be served upon the plaintiff and other defendants. This matter will appear in the list on the returnable date.
Lordship, may I be permitted to mention my application GA 150, your Lordship. Your Lordship,
Well,
this
there
is
was
an
a-
application on behalf of defendant number 10, 10A and 10B with a prayer for allotting a open car parking space in Fortune Estate, your Lordship. Admittedly, your Lordship, both defendant number 10, 10A and 10B together held
Let
3
these
point...
issues be settled. Car parking
May I make, may I?
This is a very short application. They have
My lord,
filed an opposition to our GA, your Lordship.
in
It
this,
is ready
in
for
this
hearing,
regard,
so
my lord,
Lordship may
in
kindly
this
take up.
application, lordship directed us to file an opposition, my lord. I
They
have
have filed.
What
I
is the
have-
problem with the allotting car parking area?
My lord, problem is, my lord, they are not entitled.
Lordship,
Because
may I-
when the flat was transferred, my lord, it is specifically written that they are not entitled because, my lord, it is specifically written in the order of the Supreme Court, my lord, those co-sharers who are having 3% interest in the undivided share, my lord, they will only be getting the car parking space, my lord. But there, my lord, there are 3 petitioners. They are, after adding up their all 3 shares, then it is coming up more than 3%. Now they are claiming that they are entitled to car parking space, but flat was transferred to them because at the 2017, my lord. Now with the in 2023, they are coming up with this application that they are entitled to a car parking space, my lord. Another more submission, my lord. It's a point of maintainability, my lord. I am not party to the suit, my lord. They are seeking prayer before lordship, my lord, against my client. My
you are coming with I am not a party.
Yes, my
Other
lord.
matters I am in
Lordship,
party,
Yes, my
but
lord.
order may be passed.
It is an admitted position on behalf of the developer, and a report has also been filed by the receiver, which shows that we, being the legal heir of late Arun Kumar RD, who was a co-sharer and having more than 3%, we are entitled to the car parking space. Lordship may kindly come to page 30, Page 52, your lordship. The receiver's report.
Of your application?
Of my application, your lordship. Page 52.
GA 150?
Yes, your lordship.
My lord, may I file my affidavit in opposition, my lord?
Yes.
My lord, my lord, may I seeking your lordship kindly, my lord? There is a typographical error, my lord. It will be
Then
GA
take
50.
correct it, then file it.
My lord.
Lordship may kindly come to page 52. At the bottom, your lordship would see Mrs. Mita Addi, Sujata Addi, Indrani Lord Addi. All has been taken together and the percentage of share is 3.408. Now, admittedly, your lordship, at page 43, the developer have given us, though it was a late handover, but they have handed over a flat. Admittedly, with page 43. Lordship, the letter starts, you're jointly entitled to 3.4077 undivided share. Now, Lordship, as per the direction of the Supreme Court, if your Lordship may come to page 36, the order of the Supreme Court. Paragraph 5. The respondent developer shall provide one open car parking space for only those co-sharers having 3% or more undivided interest in the properties. Now, we, defendant number 10, 10A, 10B are the substituted legal heir of one late Arun
So
Kumar
according
Addi.
to you, you are jointly entitled to
my lord.
one car parking
Yes.
space. Since the
We
area
being
is
the
3
substituted legal heir of Arun Kumar Addi, who was entitled to more than 3% share in that estate, your lordship. And that is an admitted fact on behalf of the receiver and also of the developer, while they have issued the allotment letter.
Which documents you have referred to?
Lordship, document is that the receiver's report is at page 52. And the allotment letter issued by the developer is at page 43, where they have admitted. And the order of the Supreme Court is at page 36, where it has been said that co-sharers having more than 3% share will be entitled to one open car parking space.
All right, come with your affidavit.
I have filed my affidavit, my lord.
What is your point?
My lord, your lordship, just now my learned friend referred my lord, page 52, my lord. Kindly come once, my lord, page 52. Your lordship will find, my lord, their individual share is 0.9639, 0.9639, and 0.9639. Their individual share, they are not individually more than 3%, my lord.
All right, give them jointly.
We have asked for jointly, only
my lord,
one parking.
your lordship, kindly see the Supreme Court order, my lord. Just now my learned friend referred, my page 36, my lord. My learned friend is referring paragraph number 5. But my lord, there is a clarification, my lord. Kindly come to my lord, paragraph 4 onwards. Co-sharer having less than 1% interest in the properties and have physical possession in any of the properties under the development agreement and have not sold their undivided interest may form a group. Now they are forming a group. But it is not permissible with regard in case of my lord car parking space, my lord. It is permissible to form a group in the case of my lord when there is a question of accommodation. Their accommodation has already been given because there is more than 1%. They have make a group. They have made a group.
Lordship, the question of permissibility does not arise. As per the order, it has been stated.
Don't interrupt. Should I have to tell everybody that don't interrupt, don't interrupt?
Apologies.
Don't you know the manners of the court?
তুমি যখন বললে আমি তোমাকে কিছু বলিনি তোমাকে। My lord, kindly read my lord, paragraph number 4 and 5 jointly. With regard to the my lord flat, it is permissible under the Supreme Court order that it may form a group. But in case of my lord car parking space, my lord, only those co-sharers having 3% and more. And we have given them the co-sharers accordingly, my lord. Those who have more
Your
than
point is that when the co-sharers joining together to form more than 3% share, they are not entitled to car parking.
No. That
only one individually without forming a group is entitled to or having share of 3% or more.
There is two part, my lord. One is my lord accommodation and another part is car parking space.
We're not concerned with accommodation in this application.
In this application, my lord, because my lord, you have to, my lord, since your lordship referring the, my lord, Supreme Court order, my lord, the intention of the Supreme Court order is, my lord, with regard to the, my lord, accommodation, they make form a group when they are less than 1% share. But in case of car parking space, it is specifically written those co-sharers having more than 3%. It is clearly written in page 52, my lord. Their individual share is 0.9%, 0.9639%. And not only that, my lord, when they have received the flat, they did not raise any objection. Without any objection, they have received the flat, my lord. They have taken possession of the flat, my lord. Kindly see them their letter, my lord, page 43, my lord. Without having any objection. Now in the year 2023, my lord, since your lordship asking for filing a report by the receiver with an application connecting to, my lord, 7A and 7B, now they are raising this point, my lord. Before that, they have not raised this point, my lord. Since your lordship has passed the order, my lord, with regard to the directing the receiver, my lord, to file a report, my lord, with regard to 7A and 7B, now they come up and say, my lord, I am entitled to this car parking space.
Yes.
Lordship, we have been following up with the developer because, first of all, your lordship, the allotment which was delivered to us with respect to the flat, there we were not treated as the individual co-sharer. As per the report also, your lordship, we have been treated as one co-sharer having more than 3%, and accordingly the flat was measured and the flat was delivered by the developer, your lordship. That is evident from page 43.
Respondent number 1 shall provide one open car parking space for only those co-sharers having 3%.
Yes, your lordship.
It is not clarified whether when the owners shall form a group together or club together to have added up 3% or more share, whether they will be given car parking space or not. You have to go to Supreme Court and get
Your lordship,
clarification.
I will clarify on that part. Your lordship may kindly take the allotment later. All the co-sharers, all these 3 co-sharers have been treated as one and have been allotted one flat with respect to that.
Right. Supreme Court order is different. Supreme Court order said what appears to me that co-sharers having 3% or more undivided interest.
Lordship have also identified, as per your lordship's direction of 15th March, the receiver filed the supplementary report. That is at page 53, which shows that we have more than 3% share. And because we are the legal heir of late Arun Kumar Addi, who had that more than 3% share, your lordship. Because we were substituted, now he is coming up with that stand that we are all different individual co-sharers.
My Arun Kumar Addi was not party to the agreement, man. Because Arun Kumar Addi died long back, man. They have party to the agreement individually, my lord.
The right is, lordship.
Yeah, that's what I'm saying. Other expense, they have taken other and when Arun Kumar Addi expired?
Lordship, in the year 87.
This agreement was done subsequently.
Yes.
Was entered into subsequently.
Yes, your lordship. As for the right, that was flowing from late Arun Kumar Addi.
Right. But
yes, your lordship.
In that case, you cannot say Arun Kumar Addi, who had in one point of time 3% share. The agreement is entered into with the legal heirs of Arun Kumar Addi.
Being the legal heirs of Arun Kumar Addi.
Explain why whether this interpretation can be accepted, because a lot of persons may be there who may have more than 3%.
Lordship, that is the stand of the reporter or receiver also, your lordship.
No,
as per the report file,
it is not a
before
question
this
of
honorable
reporter.
court.
It is whether this 1% or 3% in respect of present owner or past owners.
Lordship,
because past owners share may be more than 3%, but that is subsequently splitted into at the time of execution of this agreement.
I'm grateful, Lordship.
Lordship, the share that was divided on the basis of the allotment that was done.
So you have to
at
get
that point of time.
clarification. clarification from the Supreme Court order.
Lordship, they
That cannot be
may
done by-
kindly keep this application. My senior will come, and if your Lordship may be satisfied, may pass the appropriate order, Your Lordship.
My lords, may I make one submission, my lord? My learned friend is taking the advantage of my lordship was pleased to pass an order earlier, my lord. That is with regard to the my 7A and 7B, my lord, to file a report by the receiver, my lord. Now, when they take possession of this flat, my lord, in the year 2018, my lord, in the 2023, they are coming up this application pursuant to this receiver's report. My lord, I am only requesting today your lordship pass an order, my lord, to file another report by the receiver, my lord. Kindly indicate, my lord, only with regard to the 7A and 7B. Otherwise, my lord, another issue will come up.
ওই রিপোর্টটা যেটা বললাম in respect of 7A and 7B করে দেবেন। Third, GF 150 of 23 in part. Further hearing is adjourned to the returnable date.
May I just now indicate IAGA number 153 and IAGA number 154. These are very essential applications. My lord has always reposed trust upon the advocates that proper submissions will be made and my lord will be guided properly by the learned advocates. My lord will kindly come to my
application number 152-3
154.
এই দুটো নিয়ে নাও।
Dear my lord, the recalling order, my lord will kindly see the last prayer which my lord has allowed to execute and register a deed of conveyance in respect of a Shimultola property. It was pleaded in that application that the father who had deceased had made payment of the entire consideration amount pursuant to an order of 1994. Only the registration part is left, so the receiver be directed to register the conveyance in favor of the heirs of the deceased. Substitution along with the direction upon the receiver. And it was pleaded, specifically pleaded in that application.
This is in respect of which property? Which order you are referring to?
I am referring to the order it's an order passed in IAGA number 141 of 2022.
Have you annexed that order?
Yes.
Which page?
My lord, kindly, there's a
I am fixing it up hearing for a separate date, not on that date. Come and get ready.
my lord, kindly.
148. Extended number 26.
You are plaintiff.
I am party plaintiff and party.
How you can be? Are you divided?
Extended number 25. I am.
Like Jorashanda.
For the plaintiff.
Like Jorashanda.
No one.
That is why
Jorashanda became Jorashanda after death. He is living. দেখি কি আছে এই 153 154
And I will keep it on the 21st, my lord.
before vacation.
Before vacation. I will take 10 minutes, my lord, to place that app.
21st December. No, 25th first I fixed other matters. Other,
along
no,
with
not 21st. So many matters will be clubbed up.
Only, my lord, on
Come
that
on
day-
14th December.
14 days. Great.
Allah হবে এটা।
My lord, our application would be come up on 21st.
Yes.
My, I'm grateful, Lord. I'm grateful.
And your applications also on 14th. Huh? 18 December. Oh, not 14th, 18 December.
18 days. Welcome. And I will show your lordship how my lord has prescribed it. I'm
All right.
sorry to say.
Go through the record.
Yes, yes.
Item number GF 149 on 21st, returnable date.
Yes.
18 December.
18.
18
বুঝতে পারছি
19.
Your Lordship, item number 9. I appear for the plaintiff, Your Lordship.
Item 19.
On the last occasion, Your Lordship had allowed our prayer for substitution of two parties, and the department was directed to carry out the amendment. We had intimated the department, Your Lordship, but we were told that on an earlier occasion, that is March 7, 2013, defendant number 3, which used to be the Bank of Rajasthan's name, was deleted. But that amendment has not yet been carried out, Your Lordship.
To file application.
To carry out that amendment.
No, that he was deleted.
Yes, Your Lordship. By an order of Justice.
So the order is to be modified. If the substitution order is there.
Yes, Your Lordship.
And if the name of one of the substitutee is.
No, Your Lordship.
Bank of Rajasthan's name was substituted.
Bank of Rajasthan's name was deleted in 2013.
Right.
Because it got amalgamated with defendant number 8, which was already a party. And now, Your Lordship, Dena Bank, which is the defendant number 3 as of now, is has merged with Bank of Baroda. And Your Lordship allowed our prayer to bring Bank of Baroda as a defendant in the suit. And defendant number 6, that is the Ing Vyasa Bank, has merged with Kotak Mahindra Bank.
What was my order?
So in this matter, I am appearing for the defendant number added defendant number 5, defendant and defendant number 5. Last occasion I have submitted my note. Defendant added defendant Punjab National Bank, but on that one, on 3rd October 2023, there's an order. I have given liberty to file my opposition. Last page, page 3. So far, prayer H is concerned. The Land Council of Punjab National Bank have leaves to file a written opposition against the same. Leave is granted.
Then you have to file appropriate application.
For carrying out that amendment at the moment?
Amendment could not be carried out because of earlier deletion of name of that Bank of Rajasthan.
Yes.
So order may be modified. Because in the order of amendment, Bank of Rajasthan was supposed to be added or deleted or merged or whatever that might be.
Deleted.
Deleted. That was deleted earlier. My order was
to bring Bank of Baroda in place of Dena Bank and to bring in Kotak Mahindra.
Is it in respect of Bank of Rajasthan?
No, Your Lordship.
All right. Then department, then the note. Then there is no problem in carrying out.
Your Lordship, my instructions are that we've been told to take leave from Your Lordship to carry out the earlier amendment first and then carry out this amendment since it hasn't been carried out for so many years.
Let a report be called from the department.
Will it be Your Lordship's pleasure to have a look at the 2013 order?
No, let the department place a report. It is submitted by the Learned Counsel for the plaintiff that amendments as directed earlier could not be carried out. Department is directed to submit a report in this regard. Let the matter appear in the list on 20th December.
Yeah. I am paying on behalf of the Punjab National Bank, who has been added by my last order. And in this order, on 3rd October 2023, my lord given liberty me to file affidavit in respect of prayer H of the petition.
No affidavit has been served.
No, I am seeking 2 weeks time filing affidavit extension.
Why affidavit? Affidavit
Because,
against
my
what?
lord, because my lord, they are trying to inject property. We have taken step under Securitization Act.
Your Lordship,
And thereafter, we have taken step under Securitization. We raised objection on this aspect, and upon hearing submission of my lord, please to give liberty to me. So I am seeking.
Leave was granted to the Learned Counsel for Punjab National Bank in terms of order dated 3rd October 23 to file affidavit in opposition.
Yes. I am
Full stop.
seeking 2 weeks extension. my lord.
Today, 2 weeks extension is prayed for by the Learned Counsel. Full stop. Allowed. Affidavit in opposition shall be filed within the returnable date.
Another aspect, my lord. In this case, my lord, dependent of 5. I submitted the dependent of 5 was not served. It was served. So even that, I have prepared affidavit, written statement. I am seeking leave to file my written statement.
Leave is also sought for to file written statement by Punjab National Bank.
No, not Punjab, by Indian Overseas Bank.
By Indian Overseas Bank. Leave is granted to file written statement. Forthwith. Anything else?
Yes, that's
Grateful, Your Lordship.
Time being.
This is WS.
Yes, WS and competency.
Department. You file it in the department.
Then kindly give me some time so that I can.
Next.
Item number 20. Vimda Projects Private Limited.
My lord, I am for the plaintiff, my lord. Here, when Mr. Bhatta Chakraborty is appearing, he is ill, my lord, so he is not unable to appear today. My lord, the thing is that the amendment was ordered by this court and the amendment was made in the department, my lord, accordingly. But in Master Summer, there should be some reaffirmation by the client. Department yet not sent the notification to us to bring the client to make the reaffirmation. So we need some time, my lord.
Adjourn to on prayer of the Learned Counsel for the plaintiff. The matter is adjourned to 18 January.
What's the Dixon passed over matter? Item number 3.
Your Lordship, we are appearing on behalf of the petitioner. We are represented by Mr. Das. In this matter, on the last occasion, you have directed us to complete the inspection. However, that could not be completed as some of the documents are lying in this possession of the city civil court. We are the petitioner.
Number 1. The Learned Counsel for the plaintiff seeks for accommodation to finish inspection of documents. Leave is granted that this would appear in the list on 16 January. Inspections, discovery and inspection shall be done within the meantime. In the meantime.
Great.
তাহলে আবার আসতে হবে
Thank you, Lordship. Sir, we supposed to appear tomorrow. Sir,
লিস্টে দাও, লিস্টে দাও।
Lordship, I had prayed for
Is it
filing
the-
of the application with the Section 5 under Order 22, Rule 3, Lordship. So this is the Section 5 application.
Section both to be heard.
What needs to be heard?
হিয়ারিং করতে হবে, লিখতে পারতে হিয়ারিং এ আসবে। অর্ডার 22 রুল 3
Three,
করেছে, পড়ার সঙ্গে সেকশন 5 করেছে, তো হিয়ারিং না করে হবে না, এই লিভ তো দিতেই হবে। এবার সেটা অ্যালাউ করবো রিজেক্ট করবো সেটা পরের কথা, হিয়ারিং তো করতে হবে।
Grateful, Lordship.
Commercial division, item number 1.
Grateful.
Yes.
My lord, I
So
had
your
my-
first point was Supreme Court has already stated
Correct.
it is to be executed. Second point is because of section 2, this part is not applicable.
Correct. And my lord, in between, I had also said interest on interest is not contrary to public policy for a foreign award. My lord,
Yes, so far as foreign award is
correct.
concerned.
So my lord, this is a foreign award. Now, my lord, I had said, my lord, that part 1, my lord, will not apply. And my lord, and what I was to follow up on was even if part 1 were to apply, my lord, this is, my lord, in consonance with part 1. I, my lord, read out the award to show it was interest is as per contract. And my lord, on the award, my lord, is, my lord, interest which has been paid because 31(7) has two limbs.
Yes.
31(7)(a) and 31(7)(b).
So it is not offending the contract.
Yes. My lord, neither is it offending the contract, nor is it offending 31(7) of the Arbitration and Conciliation Act. That now, my lord, why, my lord, 28(3) and 31(7) will not apply? My lord, I want to rely on, my lord, the decision in Balco. My lord, this is, my lord, 2012, 9 Supreme Court cases, 552.
Yes.
My lord, kindly take, my lord, para 117 at page 618. My lord, kindly see. My lord, after discussion, my lord, on this issue, I'm just coming to the conclusions. My lord, in
Should not
fact,
make part 1 applicable.
correct. Now, kindly see, my lord, 107 and 118. It would therefore follow that if the arbitration agreement is found or held to provide for a seat place of arbitration outside India, then the provision that Arbitration Act 1996 would govern the arbitration proceeding would not make part 1 of the Arbitration Act applicable or enable the Indian courts to exercise supervisory jurisdiction over the arbitration of the award. It would only mean that the parties have contractually imported from Arbitration Act so and so those provisions which are concerned with the internal conduct of the arbitration and which are not inconsistent with the mandatory provisions of the English procedural law, Cural law. This necessarily follows from the fact that part 1 applies only to arbitration having this seat place in India. Now, my lord, kindly see 118. It was submitted by the learned counsel for the appellants that section 28 is another indication of the intention of Parliament that part 1 of the Arbitration Act was not confined to arbitrations which take place in India. We are unable to accept the submissions made by the learned counsel for the parties, as the heading of section 28 indicates its only purpose is to identify the rules that would be applicable to substance of dispute. In other words, it deals with the applicable conflict of law rules. This section makes a distinction between purely domestic arbitrations, now kindly mark the next, and international commercial arbitrations with a seat in India. Now, my lord, may I pause here? An international commercial arbitration is where one of the parties is a non-Indian, my lord, a foreigner. Now, my lord, but the seat can be India. My lord, in that case, part 1 would apply. But, my lord, not, my lord, part 1 where the seat itself is outside India, as in this case. Kindly see. This
That is
section makes a
explained in subsequent lines. That
Correct.
is explained in the subsequent
Correct,
line.
correct. This section makes a distinction between purely domestic arbitration and international commercial arbitration with a seat in India. Section 28(1)(a) makes it clear that in an arbitration under part 1 to which section 21(f) does not apply, there is no choice but for the tribunal to decide the dispute by applying Indian substantive law applicable. This is clearly to ensure that 2 or more Indian parties do not circumvent the substantive Indian law by resorting to arbitration. The provision would have an overriding effect or any other contrary provision in such contract. On the other hand, where an arbitration and part 1 is an international arbitration within so and so, parties would be free to agree to any other substantive law, and if not so agreed, the substantive law applicable would be as determined by the tribunal. The section merely shows that the legislature has segregated the domestic and international arbitration. Therefore, to suit India, conflict of law rules have been suitably modified where the arbitration is in India. This will not apply where the seat is outside India. In that event, the conflict of law rules of the country in which the arbitration takes place would have to be applied. Therefore, in our opinion, the emphasis placed on the expression where the place of arbitration is situated in India by the Learned Council is not indicative of the fact that intention of Parliament
The extraterritorial application.
So, my lord, on the face of them, this is, my lord, a 5-judge bench, my lord, of the Supreme Court. Now, my lord, kindly have a look, my lord, at, my lord, Haider case. My lord, may I cite, my lord, Haider's case? My lord, 2000.
Filing any notes of argument?
Yes, I'll give a, my lord, very short, my lord, notes of argument. My lord, 2015, 2 Supreme Court cases, 189.
Page?
My lord, 189, my lord. My lord, kindly see, my lord, paragraph. My lord, this dealt with 31(7) A and B. My lord, kindly come straight away to, my lord, paragraph 3. My lord, this, my lord, was referred to a larger bench because of, my lord, the decision in state of Haryana versus SL Arora. My lord, now, my lord, kindly come to paragraph 3 where 31(7), my lord, is set out. My lord, I've placed it, my lord, I don't want to say anything more. Kindly come to para 4, my lord, which explains it. Clause A of subsection 7 provides that where an award is made for the payment of money, the arbitral tribunal may include interest in the sum for which the award is made. My lord, I've shown your lordships the award. My lord, it includes that interest in terms of the contract. In plain terms, the provision confers a power upon the arbitral tribunal while making an award for payment of money to include interest in the sum for which the award is made on either the whole or any part of the money, and for the whole or any part of the period for the entire pre-award period between the date on which cause of action arose and the date on which award is made. My lord, this is, my lord, fulfilled, my lord, in the award itself, which I have, my lord, shown your lordship. 31(7)A deals with it. To put it differently, subsection 7A contemplates that an award inclusive of interest for the pre-award period on the entire sum directed to be paid or may be passed. The sum awarded may be the principal amount and such interest as the tribunal deems fit. If no interest is awarded, the sum comprises only the principal. Significant words occurring in clause A of subsection 7 of 31 are the sum for which the award is made. On a plain reading, this expression refers to the total amount or a sum for the payment of which the award is made. Parliament has not added a qualification like principal to the word sum, and therefore the word sum here simply means a particular amount of money. In section 31(7), this particular amount of money may include interest from date of cause of action to date of. That is, my lord, the first limb, my lord, paragraph 28, 1, 2, 3, and 4 of the award. Now, my lord, kindly come to, my lord, paragraph 7. My lord, thus, when used as a noun, as it seems to have been used in this provision, the sum simply implies means an amount of money, whatever it may include, principal and interest, or one of the two. Once the meaning of the word sum is clear, the same meaning must be ascribed to the word in clause B of subsection 7 of section 31 of the Act, where it provides that a sum directed to be paid by an arbitral award shall carry interest from the date of the award to the date of payment, that is post-award. In other words, what clause B of subsection 7 of section 31 of the Act directs is that the sum which is directed to be paid by the award, whether inclusive or shall carry interest at the rate so and so, unless otherwise ordered.
So this section provides for imposition of interest on sum of money.
Correct.
The sum may include interest,
Yes.
may not include
Correct.
interest. So there is no bar according to this decision.
Correct. I'm grateful, my lord. And my lord, the interest which is awarded on the sum, my lord, will be, my lord, 18%, or my lord, as it is amended now, I showed your lordship's current rate of interest, unless otherwise agreed. My lord, unless otherwise ordered, sorry, not agreed, unless otherwise ordered. So if it was silent, then, my lord, it would be, my lord, 18%, and now, my lord, current rate of interest, my lord, plus 2%. Now, my lord, here it's otherwise ordered, which is, my lord, compound interest at 6%, my lord.
Quarterly rest.
Yes. Now, my lord, kindly come to, my lord, one other paragraph I want to show your lordships, my lord. Kindly take para 30.
Therefore, I am inclined to hold.
Yes, my lord, this is, my lord, para 29, 30, 31, 32. My lord, it, my lord, deals with, my lord. This was a three-judge bench. My lord, Justice Bobde and Justice Sapre, my lord. My lord, is, my lord, the view I have, my lord, read out to your lordships. My lord, this is, my lord, what the...
Justice Dattu dissented.
Yes, Dattu dissented. Now, my lord, there was, my lord, a subsequent Haider as well, which, my lord, I wish to cite. Let me show you. 2016, 6 SCC 362.
Two judges bench.
Yes. My lord, kindly see, my lord, paragraph 12 at page 365. In the present appeal, the question that arises for consideration is whether the High Court, will dealing with an appeal arising from rejecting so-and-so, could have modified the award, especially the rate of interest. As we find, the learned arbitrator, while dealing with the interest component, has directed as follows. So, my lord, this is 31(7)(b). My lord, on the awarded sum, the interest. Now, therefore, in order to settle the dispute between the parties regarding basic loss suffered, I allow 5 lakhs with interest at quarterly rate from date of cause of action date till date of award. And, my lord, kindly see. And further 18% with quarterly rest from date of award till its final payment, etc. So, my lord, in the sum awarded, it had principal plus, my lord, interest at, my lord, compound rate. And on that sum awarded, there was again interest with quarterly rest. So, my lord,
that was upheld.
That was upheld. My lord, now kindly see, aforesaid direction is in consonance with recent pronouncement in Haider Consulting. Then para 13, the High Court has modified the said rate of interest by stating inter alia that after holding that the arbitrator has power to award interest on both, same has to be reasonable. The arbitrator has awarded interest at 16 with quarterly rates from so and so.
High Court set aside, High Court modified the rate and that was set aside.
At this time, we may repeat that the rate of interest is in consonance and hence there was no justification. They should have modified the results once. My lord, this is, my lord, compound interest on, my lord, the awarded sum, my lord, in an Indian award. My lord was upheld. Now, my lord, kindly take, my lord, another decision, my lord, 2022 4 SCC 116, UHL par.
Two judges bench.
Yes, my lord. My lord, kindly see, my lord, paragraph 4. For declining payment of, I'm sorry, my lord, at page 120. Lordship has that, my lord. For declining payment of compound interest awarded by learned sole arbitrator to HOL, the division bench relied on the decision of this court in state of Haryana versus SL Arora, wherein it was held that compound interest can be awarded only if there is a specific contract or authority under a statute for compounding, and there is no general discretion so and so to award. It was further held that in the absence of any provision for interest upon interest, do not have power to award interest or either for pre-award or for post-award. And I told your lordship, my lord, because of SL Arora, my lord, the matter was referred to a larger bench, which was Haider. By now, the aforesaid aspect has been set at rest by a three-judge bench of this that has overruled the verdict majority view is that post-award interest can be granted on the interest amount awarded, writing for the majority, Justice Bobde, so and so. Para 21, I'm of the view, some direct, and that in the absence of any provision of interest or interest, arbiter does not have the power of compound or so and so. Parliament has the honor to legislate and provide may award interest on the sum, meaning a sum inclusive, and this has been done by Parliament in plain language. While giving a concurring, Justice Sapre said this. Then, my lord, para 7, as the judgment on which reliance has been placed has since been overruled by a 3-judge bench, findings in the impugned judgment is not imparted to, and only simple interest is quashed and set aside.
So it can be done.
Yes, and this is, my lord, 3-judge bench and interpreted by 2 subsequent 2-judge benches. Now, my lord, so, my lord, the entire argument on, my lord, part 1 doesn't stay. But even if part 1, my lord, were to apply, my lord,
First thing, it cannot be considered.
At
The
all.
application cannot be considered in the order of the Supreme Court.
Yes.
Second view is that even if it is to be considered, part 1 does not apply.
Correct.
Even if part 1 applies, so alternative arguments we have made.
Yes. And, my lord, 4th point which I had also raised, my lord, was constructive res judicata. My lord, this point they could have taken before the Supreme Court, and they did not. In fact, my lord, your lordships will find, give me that portion, my lord, which is, my lord, in the paper book, which is, my lord, at page, my lord, 85. Achha, paper book. Is it here? My lord, I'll show your
This
lordship, my lord.
compilation is filed by them. It is your compilation or their compilation?
My lord, that's, my lord, affidavit and opposition. My lord, I'll just give, my lord, the records of this court. My lord, kindly have a look, my lord, at the records of this court.
Which you are referring to?
My lord, this is, my lord, the paper book from the first appeal, my lord, which was filed. My lord, it's not before your lordship. My lord, it's part of the records. My lord, I'll show your lordship.
Is there anything in the judgment of the Supreme Court?
Your lordship.
Is there anything in the judgment of the Supreme
Court? No. But what I'm trying to show your lordship, my lord, when they didn't raise it before the Supreme Court, my lord, they were aware of this point because they had taken it, my lord, in, my lord, the, my lord, proceedings in the appeal, which was taken up to the Supreme Court. That's all that I want to say, my lord. My lord, which is at page 114 of this paper book. My lord, kindly have a look. My lord, page 114. My lord, clause 5. My lord, these are all, my lord.
Clause
5, my lord.
V.
Yes, my lord. The claim for the, sorry, my lord, V. Claim for the question of asking for any interest at plus or at any rate did not, cannot, under any clause of the contract and or otherwise. This is, my lord, they are saying you can't even raise it before the arbitrator to make such a claim. And the, my lord, main paragraph your lordship will find, my lord, starts, my lord, at paragraph 3. They were aware, my lord, of page 90.
What is this you are showing?
My lord, this is, my lord, the affidavit in opposition to my execution application. The objections under section 48.
Page 90.
Yes. My lord, para 3, it starts. Facts and circumstances.
91.
Yes.
The International Chamber of Commerce.
My lord, kindly see, my lord, page 85 at the top. Affidavit in opposition affirmed by Dinanath Verma on 6th day of December 1985. Lordship has that, my lord? Right at the top. My lord,
Yes,
this
and
is
91C is International Chamber of Commerce.
No, my lord, before that, kindly look at the cause title. This is an extraordinary suit 11 of 2003, which is before your lordship. Then kindly take 86. 86 top, my lord. Affidavit in opposition of Hindustan Copper against a purported application and arbitration execution case 1 filed by Centro Trade, numbered as EOS number 11. This was, my lord. Then, my lord, paragraph 3, my lord, is at page 90. Kindly see the facts and circumstances. Your lordship has that, my lord?
Yes.
Facts and circumstances leading to the filing of the application for discovery, the interim injunction, as well as order of attachment may be summarized as follows. Then, my lord, kindly come to, my lord, kindly come, my lord, to, my lord, page 105. My lord, subclause 106, sorry, my lord, subclause M. My lord, at the bottom.
By reason of
the premises in terms of the said contract, Hindustan Copper was and is not liable to pay any further price of copper and delivered at the port of so and so. Then, my lord, kindly, my lord, go to, my lord, page 100 and, my lord, page 113.
Where is your other side? Oh, Mr. Shahid.
My lord, 113 at the bottom. Accordingly, Indian award has reached its finality and no further arbitration is possible and can be valid, legal or binding, and any award if passed will be void, nullity and not in. Petitioner craves leave to refer to so and so. Then, my lord, the claim of second without prejudice invoice and has been paid in full. There was no further supplies, question of further invoice, etc. does not. Claim for question for asking for any interest at so and so or any other rate did not and cannot arise under anything. They are aware of, my lord, all the contractual clauses. They didn't raise, my lord, this objection anywhere. Now, my lord, I am, my lord, on, my lord, prayer B, my lord, of, my lord, their petition.
This page of their application.
Their application, my lord.
J5.
Yes. My lord, kindly see, my lord, prayer B. My lord, at page 8. B and C, my lord, an order be made granting the award debtor leave to pay the said sum of rupees 5,51,45,313.68 to the award holder and full and final satisfaction of all its claims under the award dated 29 September. Then, my lord, C, an order be made recording that payment of so and so by the award debtor under award will fully discharge the obligation of the award debtor under the same. Now, my lord, without prejudice, because we said it can't be full and final settlement. It is not. And, my lord, so without prejudice, the payment was directed to be made and it has been made. Now, my lord, the reason why I say, my lord, it cannot be full and final settlement is, my lord, because the law is, my lord, that as I showed your lordship, section 49, my lord, once it's directed to be enforceable, my lord, which is a Supreme Court order, my lord, from then onwards, it's a decree. And, my lord, if an award is in a foreign currency, then, my lord, the Indian, my lord, equivalent, my lord, is expressed as on the date of the decree. So, my lord, the Supreme Court order, my lord, was of, my lord, 2nd of June 2020. So, the foreign currency award, my lord, has to be expressed in Indian currency as on 2nd June 2020. From then on, my lord, it will be, my lord, my lord, interest on that sum. Now, my lord, if that is the case, my lord, I'll give two cases, Forasol and Renusagar, which I cited, give the amount here. My lord, on that basis, my lord, the amount today, just give me that top sheet only here. How much is it?
But it has on this bar. What is it? This is USD.
You'll express it in Indian currency. 200 crores. Throw it away.
You file your notes of argument?
Yes, I'll give the figure there. My lord, the principle is, my lord, that as on the date of the award, it has to be expressed, my lord, in Indian, date of enforceability, it has to be expressed in Indian currency. Now, my lord, kindly get 1984 supplement. My lord, Supreme Court cases 263. My lord, kindly see para 24 at page 279. My lord, para 24. In an action to recover an amount payable in a foreign currency, 5 dates compete for selection by the court as the proper date for fixing the rate of interest at which the foreign currency amount has to be converted into the currency of the country in which the action has been commenced and decided. These dates are: 1, the date when the amount became due and payable; the date of the commencement of the action; the date of the decree; the date when the court orders execution to issue; and 5, the date when the decretal amount is paid or realized. My lord, these are the competing dates, my lord, for, my lord, expressing it in Indian currency. Then, my lord, para 25. In a case where a decree has been passed by the court in terms of an award made in foreign currency, a 6th date also enters the competition, namely the date of the award. The case before us is one in which a decree in terms of such an award has been passed by the court. Your lordship recalls, my lord, under, my lord, the Arbitration Act 1940, there had to be a decree in terms of the award. So, my lord, that is the 6th date which enters. Now, kindly come to, my lord, paragraph 70, my lord, which is, my lord, at page 313.
It would be convenient.
Yes, it would be convenient if we now set out the practice which, according to us, ought to be followed in suits in which a sum of money expressed can legitimately be claimed by the plaintiff and decreed. It is unnecessary for us to categorize the cases in which such a claim can be enforced and decreed. They have been sufficiently indicated in the English decisions referred to by us above. Such instances can, however, never be exhausted because the law cannot afford to be static but must constantly develop and progress as the society to which it applies changes its complexion and old ideologies and concepts are discarded and replaced by. Suffice it to say that the case with which we are concerned was one which fell in this category. In such a suit, the plaintiff who has not received the amount due to him in a foreign currency and therefore desires to seek the assistance of the court to recover, he can either claim the amount due to him in Indian currency or in the foreign currency. If he chooses, he can only sue for that amount as converted for this purpose, etc. Now, my lord, kindly go down, my lord, to, my lord, about 4 lines after that. The plaintiff may, however, choose the second course open to him and claim in foreign currency the amount due to him. In such a suit, the proper prayer for the plaintiff to make would be for a decree that the defendant to pay him the foreign currency sum claimed in the plain, subject to permission being granted, and that in the event not granting permission or the defendant not wanting to make payment in foreign currency, even though such permission has been granted or the defendant not making whether such permission, defendant to pay to the plaintiff the rupee equivalent of the foreign currency sum claimed at the rate of exchange prevailing on the date of the judgment. Then, my lord, kindly come to para 71. So, my lord, the test became, my lord, either from the beginning, I converted it and say this is the Indian currency decree I'm seeking. Otherwise, my lord, if I don't exercise that option, I file a suit making a claim, my lord, in foreign currency, subject to, my lord, permission of Reserve Bank of India. Or, my lord, I say foreign currency to be expressed in Indian currency as on date of the judgment, date of decree. Now, kindly come to 71. Turning now to arbitrations, on principle, there can be and should be no difference between an award made by arbitrators or an umpire and a decree of a court. In the type of cases we are concerned with here, just as the courts have power to make a decree for a sum of money expressed in a foreign currency, subject to the limitations and conditions we have set out above, the arbitrators or umpires have the power to make an award for a sum of money expressed. The arbitrator or umpire should, however, provide in the award for rate of exchange at which the sum awarded in foreign currency should be converted in the events mentioned above. This may be done by the arbitrators or umpire taking either the rate of prevailing on date of award or date of nearest or most preceding the date of award or by directing the rate of exchange at which conversion would be the date when the court pronounces judgment according to the award and passes the decree in terms thereof, or the date nearest from her. If the arbitrators or umpire omit to provide for rate of interest, this would not by itself be sufficient to invalidate the award. The court may either remit the award under section 16 or for the purpose of, or may do it by itself by taking the date of conversion as the date of its judgment or the date nearly so and so. Then, my lord, this is, my lord, and my lord, kindly come to para 73. My lord, for the reasons set out above, we hold that the learned single judge rightly took the date of the decree as the date of conversion. My lord, this is for us all when we had the 1940 Act and the Foreign Awards, my lord, Recognition and Enforcement Act of 71. Now, my lord, kindly come to, my lord, Renu Sagar, I'd given a copy, my lord, 1994 supplement 1 SCC 644. I'd cited it on compound interest. Now, my lord, kindly. Mutata. My lord, it's 1994 supplement 1 SCC, page 644. Lord, first day I could. My lord, kindly see, my lord, para 142 at page 712. The judgment, I'm sorry, my lord, judgment of the High Court passing a decree in terms is therefore affirmed. This would cover the amount awarded by the arbitral tribunal in US dollars and interest on award so and so, the date of filing of the petition for enforcement of the award in the Bombay High Court. The amount paid by Renu Sagar during the period will have to be adjusted against decretal amount, and the present liability has to be determined accordingly, calculating so and so. Now, my lord, kindly see amount awarded by arbitral tribunal, interest on so and so, less amount paid by so and so. In accordance with the decision in for us all, the said amount has to be converted into Indian rupees on the basis of the rupee-dollar exchange rate prevailing at the time of, kindly mark the words, this judgment. So the Supreme Court judgment upholding the decree, my lord, in terms of the award, as per information so and so. Now kindly come to 146, page 713. In the result, so and so are dismissed, and the decree passed by the High Court is affirmed with the direction that in terms of the award, an amount of US dollars so and so is payable by Renu Sagar to General Electric, out of which a sum of so and so has already been paid by Renu Sagar in discharge of the decretal amount, and the balance amount payable by Renu Sagar under decree, which amounts to conversion at so and so prevalent at the time of this judgment come. So, my lord, is the Supreme Court judgment, my lord, which is, my lord, the, my lord, relevant. And, my lord, kindly take the Delhi High Court decision, my lord, dealing with, my lord, the new act, my lord, 2022 SCC online, Delhi 949.
Page?
My lord, page, my lord, para, kindly take 21, my lord. Para 21. This was a, my lord, foreign. No, not, no, my lord, this is, my lord, an Indian, my lord, award. But, my lord, it also becomes, my lord, enforceable. Now, kindly take para 21. Admittedly, the agreement between the parties does not contain any provision regarding conversion of foreign currency component in Indian rupees. Thus, the arbitral award must be enforced on its own terms. However, the arbitral award does not indicate the conversion rate for
The
compute.
principle is that the decree, the date on which decree
He had
became
pick up,
final.
that's for us all, which I cited. So it considers for us all. Kindly come to at 22, para 23 is Renu Sagar, my lord, which I had, my lord, cited. And kindly come, my lord, to para 32. My lord, 33 and 34. The contention that decision in for us all is required was a foreign entity is not persuasive. This court finds it difficult to accept that an executing court would determine the exchange rate to be used for enforcing decrees based on whether both parties are. It is not necessary that commercial transactions between Indian parties be combined. There may be transactions which may entail exposure in foreign currency. No distinction can be made between which are in foreign currency on the basis of nationality. In view of the above, exchange rate to be applied, computing the amount due and payable.
Date on which this is SLP was dismissed by the
Correct,
Supreme Court.
correct. My lord, so my lord, it is the date of decree, section 49. I've shown your lordship. And my lord, why will Supreme Court apply? My lord, first, my lord, the learned single judge of this court held the award to be enforceable. That was set aside, my lord, by my lord, the division bench. My lord, Supreme Court, my lord, 2 rounds, my lord, before the Supreme Court. Ultimately, Supreme Court's order was go and enforce it. It has to be enforced. That is the date, my lord, because my lord, first.
What finality?
Correct. My lord, Gojar brothers, my lord, merger, doctrine of merger. That's the final order, my lord, which, my lord, is being executed. My lord, and section 49, your lordship will find, my lord, holds, my lord, provides, my lord, that, my lord, if I may just read out, where the court is satisfied for an award is enforceable under this chapter, the award shall be deemed to be a decree of that. Section 49, my lord, of, my lord, part 2. My lord, award becomes a decree. And my lord, 74, 2 Supreme Court cases, 453, my lord, finality, my lord, is accorded. And that is, my lord, what has to be executed. My lord, kindly take paragraph 11. At page 458, my lord.
This case was referred to.
My lord,
this case is referred to.
Yes, yes, yes. Now, my lord, lordship's right. The juristic justification of the doctrine of merger may be sought in the principle that there cannot be at one and the same time more than one operative order governing the same service. Therefore, the judgment of an inferior court, if subjected to an examination by the superior court, ceases to have existence in the eye of law and is treated as being superseded by the judgment of the superior court. In other words, judgment of inferior court loses its identity by its merger with the judgment of the superior court. And my lord, kindly take my lord 16, para 16.
In case.
Yes, my lord, I think my learned friend, my lord, is.
You will argue or reply next week?
Now, my lord, kindly see para 16, my lord. In cases where the decree of the trial court is carried in appeal and the appellate court disposes of the appeal after a contested hearing, the decree to be executed is the decree of the appellate court and not of the trial court. Lordship has that, my lord?
Yes.
And my lord, that is, my lord, the position, my lord, here. My lord, it has to be. And para 17. At page 460, an application of this very principle yields a result that if the Court of Appeal confirms, varies or reverses the decree of the lower court, decree of the appellate court is the only decree that can be amended, or that the limitation for executing a decree runs from the date of the decree capable, and that is the decree of the appellate court which supersedes that of the court of first instance, or that mean profits are ordered from date of suit until expiry of the after decree. The decree to be considered is the decree capable of execution, so that if the decree of trial court is confirmed, 3 years will begin to run from date of.
Para 19 is detailed.
Yes, fundamental reason of the rule, where the decree
It
to be.
to be decree of the appellate court.
That's my lord. So, my lord, in my respectful submission, my lord, it has to be, my lord, from date of enforcement as directed by the Supreme.
If your first argument, first limb of argument stands.
That's the end. And my lord, the quantum, my lord, prayer B, my lord, this will become relevant. So
if your first limb of argument succeeds, then whole thing will go.
Yes, correct, absolutely.
Gone into.
Yes.
All right.
And my lord,
argument, when will be coming? When will be coming with the notes of argument?
My lord, kindly give me, my lord,
my lord,
I'll give it after they conclude, so that, my lord, in case I.
When will you come?
my lord, on 11th, my senior has taken daytime.
Hard in part? adjourned to 11th January. Sorry, 11th December. 11th is next Monday.
Yes, my lord. And my lord, one thing I just wanted to indicate, my lord, payment which they have made for 5 crores, my lord, that, my lord, is up to me, my lord, how I wish to, my lord, adjust it. And my lord, the law, your lordship's aware, my lord, if nothing is mentioned against what it is being paid for, my lord, then, my lord, it will be adjusted against interest. My lord, there's a Supreme Court judgment I'm relying on. That's 1999, 3 Supreme Court cases, page 8.
You attach that in your notes.
Yes, I'll do that. I'm just indicate that. And my lord, I'll indicate what is today payable after giving that adjustment in the note. Yes.
questioning a commercial matter where your lordship has passed an order appointing a commissioner to take evidence. I was only, my limited prayer was this, because it is a commercial suit, that the affidavit, evidence in chief may be by way of affidavit, but there's no provision as such in the order. Kindly
tomorrow.
keeps it, to be mentioned tomorrow. I'll give notice to the other side. I've given them notice.
Monday.
Very well, I'm grateful. I'm grateful.
Give a notice.
I'll give notice and I'll come on Monday. I'm grateful.
Well, may I also pray for one extreme indulgence?
Yes.
Well, there are two matters which are fixed at 2 p.m.
Yes.
Well, item number
Up to
21 and 22. So, for arguments, my lord.
21 is your matter.
No, my lord. What I was 22 is that matter where that's so. My lord, 21, my learned friend's matter. I was respectfully submitting if 22 could be taken up before 21, because today everything is ready. So I'll just not take more than 5-10 minutes.
May I have my lord?
Is in 21?
My lord, I am appearing on behalf of the plaintiff.
Yes, Mr. Bosch argued last day.
On the last occasion, they took time and your lordship made it preemptive.
Yes.
Today they have to start arguments.
Either plenty will start argument, I will close it. Anyone? Yes.
May I have?
But just 22, if your lordship takes it up, I'll not
Yes.
take more than 10 minutes.
May I have my lord's kind leave to mention two matters, your lordship, item number 23 and 24, your lordship, the counsel who was appearing in this matter, your lordship, she's gone on maternity leave, your lordship. I'm praying for some time,
Who is
your
the other
lordship.
side?
I don't see.
When it will be called, mention it. Yes.
Didn't note it yet. Black gulo khule do. Item 22. Alienation. Look, this is the note with yes, with everything in order. The note with the judgments that we wish to rely on.
Your lordship, we are not yet aware of what the judgments the petitioner is citing, the defendant.
Give a copy.
We have already given the judgment. That's all. That's all. Nothing. No. No new judgment. No new judgment.
Very well.
No new judgment. Because I'm in reply. Mr. Ghosh has finished. I'm just in reply, just clarification, if at all, if anything is required. My lord, your lordship will see. My lord, there are. I'll just, my lord, briefly, my lord, point out certain undisputed fact. Registered lease 99 years, not in dispute.
Rent is not in dispute.
Rent quantum not in dispute. Plaintiff's case in the plaint 1400.
Only components of rent are in dispute.
Yes. Now, at this stage, now when the point is being taken, now they say, now this is their defense to the point taken by us that this suit is not maintainable before this honorable court in view of the threshold limit of the rent and the fact that this is a protected tenancy under the Premises Tenancy Act, because it's based out of a registered lease which was registered prior to the commencement of the 1956 Act. So now, as by way of a defense, they say that municipal rates and taxes formed a part of the rent, and municipal rates of taxes is much in excess. Now, well, first I will address that question because that is possibly the only question that has been raised as a defense to our preliminary issue. Lord, the moment it comes to municipal rates and taxes, Lord, assuming what by the other side has said is correct, municipal rates and taxes should be taken into consideration. Lord, there cannot be a variable. There is no quantum of municipal rates and taxes. Who will pay the municipal rates and taxes? Because this is a multi-occupancy building. The lease provides that this is not a regular lease of a limited area. It is of the land with a right to the lessee to construct and let it out. So, my lord, when the lease was executed in 1965, there was no building. So the building is constructed, and in the multi-storied building which was constructed, there are several occupants. No, my lord, so thereafter there has been an assessment of municipal tax.
One argument may be raised that rent is one. which is payable
Correct.
by the tenant
Yes.
to the landlord.
I know.
If municipal tax is included,
Yes.
municipal tax under Kolkata Municipal Corporation Act,
My lord.
proportionate share can be paid by tenant to the corporation.
My lord.
So that component is not payable by the tenant to the landlord.
My lord, now, my lord, my answer would be, my lord, there can be various lease deeds. My lord, there cannot be a proposition which is contrary to a contract. My lord, these propositions are based on a contract between the parties. My lord, if there is a contract to the contrary, that will supersede or that will have primacy. Here is a contract that there are several financial obligations of the lessee, which includes the financial liability of payment of taxes, whatever it may be, construction of the building, maintenance, everything is the liability. But the lease deed provides, your lordship will see the lease deed, we've indicated the relevant clauses of the lease deed. It provides the breakup of rent. Once the breakup of rent is provided, the intention of the parties is clear, and there is a separate clause which creates or casts an obligation on the lessee for payment of municipal taxes. There are several other clauses which creates other financial obligations on the lessee as well, because the lease was such. It was a 99 years lease. It has the
point is, one is financial obligation.
Yes.
Second is liability of the lessor or tenant to pay an amount known as rent to the landlord, or in other words, the amount payable but for occupation of the land or premises or whatever that might be, is rent. That which is not payable to the landlord, which the tenant can pay to the corporation, definitely is not form part of the
and which is provided in the agreement.
Irrespective of
that, this is what is payable to me. Now,
irrespective of that.
Irrespective. And my lord, there is no thing that this property, if your lordship will see the municipal tax part, why I say it cannot be included in this contract or in the subject matter of this case, because they are distinctly different. Apart from the variability of the municipal rates and taxes, the intention of the parties was never to make it a part of the rent. The judgments that has been relied upon are where the contract provides that I do not dispute the proposition that in given cases, rent includes municipal taxes. But my argument is, but not in all cases. So
it depends. According to you, it depends.
It depends. It depends on the facts of that case. So those judgments have to applied in the context in which they applied. So this is, this judgment, this proposition has been laid down by a coordinate bench of our court, which has been given as a part of our note. I have also relied upon that. That your lordship will find the judgment. Yes, EIH Limited versus
EIH.
Yes, that is the first in our compilation. That's the first judgment. I have already relied upon that. I have also given the relevant paragraph where it has it. So that's the real test, so to say. This is one aspect of it. The other aspect, or the most important aspect, is why do they say it will not form? It will not be covered under statute. My lord, their argument that this sooner determination concept, my lord, which arose Prakash Bhatti Chopra and thereafter the coordinate bench judgment in the case of my lord Ashwin Bhanulal Desai. Lord, your lordship will see now the law is clear that if the lease has run its entire tenure, then regardless of the quantum of rent, I'm not on the quantum of rent, only on the tenure of the lease, then it would be governed under the Transfer Property Act. Now, whether it is a determination under section 111, any of the clauses, or by virtue of a sooner determination clause in the agreement, which gives a right to the lessor to terminate, that by itself takes it away from the purview of the Transfer Property Act and gives a protection to the lessee under the Premises Tenancy Act, provided the threshold limit is satisfied. So that is the other aspect. So then what remains, if your lordship will kindly once take our note, my lord, at paragraph 3, initially we've given, at paragraph 3, we've given the relevant clauses and the cross-examination, where your lord will find from that compilation of paper book that we've handed over. My lord, then we refer to at para 7, the coordinate bench judgment. Then your lordship will take we deal at para 10, my learned friend's argument that when the municipal rates and taxes forms a part of the rent. And then, my lord, at para 11, we've referred to the EIH hotel judgment. There we've said that, my lord, it has been unequivocally held that the amount which is variable in nature and depends on certain contingencies cannot be characterized as rent, cannot be made for part of that. Now, this coordinate bench judgment in the case of EIH hotel, my lord, went up to the Supreme Court. Well, that your lordship will find at paragraph 11.
Yes, you have shown that.
Yes, my lord. And we've also given that, and this judgment was affirmed. So this is number 2. Now, my lord, your lordship will see. So now there was one more argument which was advanced by Mr. Ghosh, that while hearing this application, what are the options? Your lordship, they said that your lordship can see that this is a triable issue, whether rent becomes so you can send it for trial. Well, if your lordship will kindly see the order by which the preliminary issues were framed, well, this order is the first annexure to our note. I will just show your lordship the relevant, because this
that you missed plus day.
My lord?
This you missed plus day.
Yes, I did. Well, lord, here, this argument which has been advanced now was addressed. Lord, after considering the submissions of the party, if your lordship will see, internal page 2 is my argument. Then, if your lordship will come to internal page 3, Mr. Ghosh opposes the contentions on the ground that the present case is one of mixed question of fact and law, as the amount of rent would also include unpaid corporation taxes, which would take the total amount outside the purview of the 97 Act. Counsel further submits that the evidence should be permitted to be completed for the plaintiff to depose on the factual issue. Counsel submits that the Supreme Court, such and such, from which the revisional application arose, lending the decision in the Vijay Kumar, Manish Kumar, had admitted such and such. The essence of the plaintiff says that the transfer property will apply. Thereafter, your lordship will kindly consider order 14, Ashwani Bhanubai Desai, and then the court held at internal page 5, by reason of the above, GA 340 of 2020 of the defendant number 2 is allowed in terms of prayer A. Issue number 1 and 6 as framed shall be treated as preliminary issues. Learned counsel for the parties will be called upon to make arguments on these issues on such and such. So now, my lord, this order has been accepted. There's no appeal from this order. So, my lord, once this order has reached a finality, my lord, the question of what Mr. Ghosh has suggested that this should be decided on trial, my lord, these arguments were made while this application was being considered. So, my lord, that those submissions and the prayer made by Mr. Ghosh was negated, not considered, or considered and rejected, and reached a finality. So, my lord, now this option in my respectful submission may not be available for sending this issue to trial again. So, this is now the preliminary issue under Order 14 Rule 2. This has to be decided. Under Order 14 Rule 2, this is the issue which requires, no evidence is required in respect of this. This is a pure question of law which requires to be decided. These are my respectful submission.
Reserved for order.
Your lordship.
So kindly grants us one day to rejoin for 10 minutes.
Rejoinder, after rejoinder, that
Your
cannot
Lordship,
work.
I'll show why. His judgment, unlike what has been submitted to your Lordship, the judgment of EIH versus Nadia Virji was shown while after our arguments, not before that.
No, it was shown earlier.
No, your Lordship. This we have received it. We have followed our notes. We found out that this has been shown after our arguments. On the 22nd September hearing, not before that.
Come on 13th.
Grateful, your Lordship.
Heard in part, fixed 13 December for further hearing.
Right.
Item 21.
21.
On the last occasion, I couldn't appear. I'm extremely sorry for that and tender my unqualified apology for that because of my health reasons. I have a knee
All
problem.
right, you start argument.
At the first instance, I will take your Lordship to the Benami Transaction and Prohibition Act, which they have argued that under that act, this suit is not maintainable. If your Lordship kindly comes to the prayers of the plain.
Plain written statement to read.
This is a suit for partition where the plaintiffs claim that all the properties owned by the defendants and the plaintiffs are jointly owned, and the defendant, on the other hand, claims that it is a singular and individual property. So the question of partition does not arise, as alleged by the plaintiff. My Lord, if I may take your Lordship to the prayers of the plaintiff. A, B are now C. An account
dealing with defendants.
Dealing with the defendant. With regard to the immovable property. Discovery of assets acquired by the defendant number 2 to the original defendant number 4 out of the joint business and joint properties and possessed by them. Necessary direction. Now, if declaration that the immovable properties being premises number 33 Monroe Street, 17/2 Siptola Lane, as described in the Schedule A, are the joint properties of the plaintiff number 1 and original plaintiff number 2 and the original defendant number 1, who are jointly ostensible owners of the said 3 premises in equal shares. There are other properties of G. Declaration that the business under the name of Style Depot Medical Hall in a rented shop room at premises number such and such, including the tenancy of the shop room thereof, hardware business under the name and style of such and such, including the tenancy in respect of such and such.
What is your point? Their point is that basically these properties, you have nothing to show. These properties were purchased out of joint fund. What is your reply?
This property was purchased out of the joint fund.
What evidence have you
my
adduced?
Case. Malad, I shall take your Lordship to that later. Malad, now as regards the Benami Transaction and Prohibition Act, we have purported to allege that this suit is not maintainable.
First thing, Benami Transaction Act is not applicable to this suit because it had no retrospective
Prior
effect.
to the yes, the 1988 Act has prospective, not retrospective. It was decided earlier by the Supreme Court that it is retrospective, but subsequently,
yes,
a larger bench held that it is prospective. I can refer to the decision also. I shall give that decision also. Now, my lord, second point is that they had filed a suit before the Small Causes Court at Calcutta in 1978 for eviction and possession of the property. My lord, that the fate of that suit is still unknown. They couldn't produce any document that the suit is still alive. So, in that event, the suit that alleged to have been filed, not alleged, it has been filed, but there is no trace of any evidence whether any order was passed in that suit. My lord, in that event, kindly let me take your lordship straight away to the evidence.
Evidence of what?
Evidence of the plaintiff.
Evidence of?
Plaintiff. The question here. Now, my lord, straight away come to the question number 61 to 64. I am producing a document being PD number 50. Kindly look at the document and tell what the document is about. Please, it contains the accounts of balance sheet and profit and loss of Mondal and Company. Could you tell as to who prepared this document? Saujam Mondal. That was the original defendant number 1. Do you know his handwriting? Yes, I know. Do you admit the contents of this document? Yes, everything in this statement is true and correct. Tendered and marked as Exhibit A. Now, my lord, judges before document the barcode. Here is the defendant. Judges before document the barcode. Judges before document the barcode. Judges before document the barcode. Huh? My lord, I am extremely sorry, my lord. Please wait. Now, my lord, kindly turn to page 92, PD 50 from pages 92 to 154 of the judge's brief of document. Hmm? 92 second. 92 to 154.
Yes.
This is a bit illegible, but I'm trying to get through it for the convenience of your lordship. Full and borrow suit.
Which page you are referring to?
Huh?
Which page you are referring
92.
to? Jivan Ram Gangaram. Rent receipts.
No. PD 50. PD 50 is item number 20 of my judge's brief of document.
No, nothing there is. There is nothing like that.
Subject to Lordship's approval, may I kindly have a look at the
No. Notes of argument and come with this. Otherwise, it will not tally. It will take time. Prepare a notes of argument because these pages are not tallying with each other.
Yes.
So refer to that notes of argument, prepare notes of argument, come back with that notes of argument. I will go through that only. How long will it take to prepare that?
I was thinking of retiring from the because of my knee problem. I had advised my client to engage another counsel so that he might not face any difficulty. Your Lordship may kindly give me 10 days. 10 days? I shall
10 days
definitely-
finish argument, I will reserve it for judgment.
My lord.
Before retiring, I will want to finish it.
Lordship, in that event, your Lordship passes direction so that both the parties can file their written notes on a day before
Heard
the
in
vacation.
part, heard the learned counsel for the plaintiff in part. Both the parties are at liberty to file written notes of argument on the next date. Let the suit appear in the list on 18 December.
18 December.
If any clarification, your Lordship can call upon us before the vacation and we can clarify.
My lord.
18 December,
I-
come with notes of
definitely,
argument.
I will definitely.
You did not trouble yourself a lot. Just prepare notes of argument and come back.
Lordship, if my learned friend indicates the judgments which
Let
he
that
rely
be
on-
filed. Let the notes of argument be filed, then further order.
Lordship, then I'll hold on to my written notes because I have to deal with his judgments. Whatever he
Let
realizes.
that be filed.
Lordship, that's on 18, not for me then.
Next.
It will be a compendium of judgment.
Item number 23 and 24, witness action.
এগুলো একসঙ্গে রেখে দাও এগুলো একসঙ্গে রেখে দাও এগুলো আলাদা করে রাখো এখানে বার করো ওখানে গুছিও না ওখানে গুছিও না ওখানে গুছিও না
Item number 25 to 27.
Who is for the plaintiff?
Your Lordship,
আগের order sheet টা দেখে।
Your Lordship, I filed my wakalatnama in the matter as per the registry's requirement. The other side was speaking of authority for which I was appearing for my mother. Your Lordship, my affidavit in competency and the wakalat.
None appears for the plaintiff. No witness is produced. Previous occasion, the plaintiff sought for an accommodation on the ground of personal inconvenience. The suit is adjourned for witness action to 10 January.
Your Lordship,
Adjournment is peremptory.
Your Lordship, I just need just one little submission I have. There's a written notes of arguments I've prepared. I don't want.
Why written notes of arguments are filed?
Not for that. Written notes of submission because there are certain points.
No, when it is filed?
Yes, Your Lordship, but
When
it is
filed?
an out
When it's filed?
because there are three applications which are being listed with this app with the contempt app.
No.
With the main
This is
suit.
not listed today. Today, the matter is appearing for witness action. Those matters are not to be clubbed. If you are not able to understand court proceeding, appoint a lawyer, or better, this is the right case where I should release this matter without making my headache.
Your Lordship, the matters, the three applications are being listed with the suit, and
Matter is released from this court. It may be placed to some other court.
Item number 28.
এটা রিলিজ করে দাও। না কোনো অর্ডার থাকবে না। প্লেনটিফ অ্যাপিয়ার করলো না। The matter is released from this court.
We were there for some of the defendants. We're just giving order.
I am releasing this. Go to other court. I don't like to take any further headache.
Your Lordship, item number 28, Your Lordship, I'm for the plaintiff. My witness could not be here, Your Lordship. I'm due to some medical emergency, he's out of station. Kindly keeps
Adjourn
it-
to prayer of the learned counsel for the plaintiff. Is it expertly?
No, Your Lordship.
Adjourn to 17 January,
Lordship keeps it on the 18th or 19th.
30th January. Okay.
Item 29.
Excuse me. My lord, appearing for the plaintiff, my lord. I'm praying a short password, my lord.
This is the last matter.
My lord, it's my
Further, my lord, plaintiff, my lord,
Witness,
my lord, witness, my lord, has not, my lord, some,
when will you come?
my lord, kindly gives me time till January because, my lord, it is a company.
PCS.
And, my lord, another, my lord, issue, my lord, is there. My lord, the issue, the dispute which is there, it is one of commercial nature, it's commercial nature. The reason why, my lord, because, my lord, the tenanted premises which is being under, that's what's under commercial. So, therefore, my lord,
The learned counsel for the plaintiff seeks for an accommodation.
I'll also take out an
Peter?
application, my lord, for transfer, even, my lord.
It is also submitted by the learned counsel for the plaintiff that matter should appear in the list of the commercial division since the dispute involves commercial issue. Dispute involved is commercial in nature.
I'm grateful, my lord.
Let the matter be transferred to commercial division.
I'm so grateful, my lord. I'm very grateful, my lord. Really grateful.
Department is directed to do the needful. The suit will appear in the list of commercial division on
Sometime in January, my lord, by request, my lord. That's why, my lord, humble, my lord, prayer, my lord, for my lordship, my lord.
19 January.
Grateful, my lord. Will come back, my lord. Grateful. Highly obliged, my lord. Sir, अच्छा, my lord.
Let me take it up.
Grateful, my lord.